I guess what we need to figure out at this point is how to bring all this to scale. So it's 3,500 courts, which is amazing, starting from 1 to jumping to 3,500. But that's a drop in the bucket. And if I had my way, if I were empress of the world, every court would be a problem-solving court. Every court would have the resources it needs to address these issues. And that's not because everybody else is doing a bad job. It's just that we haven't looked at the court as a problem-solving, holistic entity before. And it can be with partnerships in the community. It's just a different way to focus on what these issues are. Because the person who's homeless, who's getting in trouble with the law, who's scaring children at the park, who may be mentally ill, who may be committing crimes, who may have a substance abuse problem, is in and out of homeless shelters, the emergency room, the mental health system, the drug treatment system, the court system, and it's a huge recycling over and over again. And at every juncture, it's the most expensive way to treat them. The emergency room is much more expensive than primary care. The emergency mental health system may cost, for somebody with schizophrenia who has to be remedicated, who's gone off their medication, it may cost upwards of $150,000 per treatment episode in an acute care kind of setting. For the substance abuse, increased medical costs, lost productivity, health care, let alone 400 crimes a year on the average. Driving while impaired, the human toll of that crime. All these things are now being treated when it's acute and in the most expensive way. And we have to find a way to bring these resources to scale. We have to find a way to start in law school. And now there are 2 law societies for therapeutic jurisprudence, talking to very, very young people in their beginning of their career to start looking at a whole different way of behaving. We've made inroads in law school, which was another reason Bill and I early wanted to write a law review article. I mean, there's nothing fun about writing a law review article, believe me, looking at those bloody footnotes, 15 times. The last one has 603 footnotes. The sun came up, footnote. So the idea was to try to get academia to pay attention. Hey, there's this whole revolution going on out here and you have no idea. And you're teaching these students who will have no idea. To get lawyers to trust, particularly criminal defense attorneys who have been very wary about this movement. On the one hand, the prosecutors, who at first called it a hug-a-thug program, they came around faster than criminal defense attorneys, which was kind of counterintuitive. Says, geez, your people are going to be helped instead of hurt. How can this, how can this be bad? They've been the least embracing, and that's starting to turn around. And the National Association of Legal Aid Defenders has issued some guidelines on problem-solving courts and so forth. So some of these areas are just starting to be mined. There's a lot of people that still don't know what you're talking about when you talk about a problem-solving court. And for those of us who have been up to our eyebrows in it, you could say, gosh, how could there be anybody in the United States who hasn't heard about this, let alone in the rest of the world? But that's not true, because who do I talk to? I talk to my friends who think like me, So that's the next challenge, is how do we move this forward? How do we turn every court into a problem-solving court? How do we teach judges how to use these principles? How do we teach attorneys how to trust that system, that nobody gets hurt? The public stays protected, the individual defendant is not denied rights, and we get better outcomes on both public safety and less incarceration and fewer contacts with the system for the criminal defendant. How do we make probation's job easier? Instead of having a caseload that's totally unmanageable, you have people who are actually in recovery and doing well, and they're not going to be the problem children that they are now, where all you get to do is just file petition after petition after petition to revoke. And instead, what you could be doing is saying, gosh, you're doing a great job, and bring probation officers back to their original charge. In Australia, for instance, and in Israel, every probation officer is a social worker, has a social work degree. That was the original vision of a probation officer. Then somehow probation officer became cop, another arm of law enforcement. Probation went from court employees to employees of the executive branch. And with those shifts came the mentality of lock them up, throw away the key, 3 strikes you're out, all these things that we've tried and said, now we're saying it's way too expensive, it's way counterproductive, and it ruins people's lives in a way that they don't have to be ruined. I think we can now see that we can redirect those resources and bring people back to where they were. In California, we just changed the name of the Department of Corrections to the Department of Corrections and Rehabilitation. That R word is back. People are saying rehabilitation without going snark, snark, you know, there is no such thing. People believe that people can change. We know what good treatment is. We know what works. We know why it happens. And so we're in a better position now than ever before of actually improving people's lives.